Well, good afternoon, everybody, and welcome to the third installment of the McGuire-Woods COVID-19 Employment Webinar Series, Legal Guardrails, Guidelines, and Developments. Today, our topic is actually a continuation of our earlier webinar on March the 24th regarding paid FMLA and paid sick leave under the new Families First Coronavirus Response Act. Specifically, today we'll be covering key concepts, takeaways, and surprises in the new DOL regulations regarding FFCRA that were issued at the very end of last week. My name is Brian Barger, and today joining me is my fellow labor and employment team member, Peter Farley. Thanks again to everybody for tuning in. We know it is a crazy time with lots of demands on your calendar, personally and at work. So we very much appreciate your joining us, and we hope that today's webinar will be of some help to you in navigating these complex new regs. Before we dive in, let me just mention a few items about the platform itself. So on your screen, you should see several widgets toward the bottom. First, there should be a green meeting materials widget towards the bottom that includes a copy of the presentation itself. Separate from that, a link to those materials will also be sent to you via email, which you can use for yourself or you can share with others. Second, you should also see a purple Q&A feature. You can use that Q&A to submit any questions that you have throughout the webinar. We'll be leaving all questions to the end of the program, and we'll do our best to get to what we can, but frankly, there's a lot to cover. And so if you have questions that we do not get a chance to address, we'll try to follow up with you individually after the program is over, or you can simply email Peter or me directly using the contact information at the end of the deck. Please also note that this presentation is being recorded. We'll circulate a link to the recording itself together with the webinar deck after the presentation is over. Also, for all attorneys who are on the line, CLE credit is in process, and we will apply the credit to the bar number submitted when you originally registered. If you have questions about that, or if you didn't provide your bar number to us during registration, please contact Laura Pickert at our firm. Her contact information is contained in the webinar invite sent to you earlier, and it will be in the follow-up email after the presentation. So that's it. Now on to the regs themselves. So I can't speak for any of you, but at least for me, every day now feels a little bit like Groundhog Day. And if you haven't seen the movie before, this is a movie with Bill Murray where he wakes up every morning and every day is exactly just like the day before. And to me, that's what all this COVID experience sort of feels like. I wake up every morning and I have to ask myself, am I still COVIDing? And the quick answer normally is, unfortunately, you bet. So here's a photo that a lot of you might relate to. You might be asking yourself, is that Bill Murray from Groundhog Day? Actually, no, that's me and my wife this morning at breakfast. To me, frankly, there's not enough coffee in the world to keep up with the speed of developments that we're getting, not just with respect to FFCRA, but with respect to the CARES Act and a slew of other regulations that affect industries nationwide. But today we're going to try and do our best to get you up to speed. So what we're going to cover is quickly, initially, a FFCRA recap. We had a webinar earlier about the outlines of the Family First Act itself, but we'll try and do sort of a recap refresher just to get us into the moment. We'll also then dive into the regs themselves, talk about things that we are seeing that are nuances or differences with respect to who's covered, who's not, and exceptions to that, the rules about the inability to work, how all that applies to shelter in place and to furloughs, which I know is on the top of a lot of folks' minds. And we'll also try and deal with other regulatory clarifications and surprises that jump out to us from the regs. I will tell you there are lots of things in the regs that surprise us, and there are a lot of little niches here and there that will impact how you operationally sort of move forward with FFCRA. But again, we're trying to sort of cover key concepts, and to the extent, again, you have questions later, please reach out to Peter and me and others on our labor and employment team, and we'll do the best we can to get to them. So with that, let me turn it on over to Peter to get us started.
Sorry, advanced this too fast. Thank you, Brian, and thanks everyone for joining us again today. We appreciate the opportunity to talk with you all about the statute and go over some of the things that we're seeing in the regs and developments that will certainly get fleshed out more as we have this statute and the regs go into effect and employers and employees start to deal with their specific circumstances. Just quickly, kind of how did we get here? Where are we now, so to speak? The statute was first passed on March 18th. It was the first COVID-19 federal legislation. The DOL, the United States Department of Labor, issued FAQs beginning on March 24th, and they have been pretty good at updating those FAQs and did so again on March 28th, and as I noted later on in the slide, again revised them on April 5th. Those FAQs followed the issuance of the temporary regulations related to this law. So I would recommend that you review the FAQs on the Department of Labor website. They are pretty good and fairly comprehensive, and they're being added to regularly, at least at the current time. We'll see if they continue to get updated weeks ahead. We certainly expect further regulatory guidance and refinement. The regs that were issued on April 1st are temporary regs. If you looked at them, you notice there's a lot of information in the preamble. In fact, the total document's a little over 100 pages, and only about 25 or 30 or so are regs. The rest is really preamble. So there's a lot of information in there, and we're going to try to summarize the key points for you today. So let's, as Brian indicated, go through a recap of what the Families First Act provides, just to kind of level set where we are and make sure you guys have a good baseline of the key concepts. So, as you know, there are two types of leave that the Families First Act provides. The first is emergency paid sick leave, and the second is an expansion to the Family Medical Leave Act called Emergency Paid Family and Medical Leave. So for sick leave, it's up to 80 hours, 2 weeks or equivalent for part-time. It's all paid, and there are 6 separate triggering events. 1 through 5, I'll go over in a minute, are fairly specific. A 6th one relates to additional bases that the Secretary of Health and Human Services can issue, but there are 6 for the paid sick leave. For the emergency family medical leave, it's 12 weeks of leave. We'll talk a little bit later in the program about how that 12 weeks meshes with the regular FMLA. The first 2 weeks of that leave are unpaid. The remaining 10 weeks are paid. And there's only one triggering event for emergency family leave, and it's the same as the 5th reason under the sick leave, to care for a child. We'll get into that in a second. Just want to note here, the regs confirm this, and we suspected this would be the case, that the sick leave, or the family leave, can run concurrently with the sick leave. So we'll go into a little bit more detail in that on that issue later, but just to keep that in mind that these two can run concurrently. So let's first start with the sick leave reasons. And if you've had a chance to look through the materials or attended our last webinar or whatever, these will be pretty familiar to you. I'll note a couple of points just about them as we move through this, but we'll discuss it in more detail in a little bit. So the first 3, you have a quarantine, a self-quarantine, or symptoms and diagnosis. So for quarantine, the key thing to keep in mind here is that you, the employee, is not able to work, but the company has work for you. because you're in a quarantine, and that's a federal, state, or local isolation order. Same thing relates to a self-quarantine. And this one is you can't work because a healthcare provider has said that you have to self-quarantine. So just want to remember two things there. Then, well, first, the work is available. The business hasn't been closed. And second, that a healthcare provider has advised you of this. And we'll get into details about what all that means. The third one is you've got symptoms or diagnosis for COVID or COVID-19, and very important, you're seeking a medical diagnosis. The regs talk about taking affirmative steps to do so. And we'll get into a little bit of detail on that, but this one really was fleshed out well in the regs. There's certainly going to be additional questions for that, but that has been helpful as it's been expanded. The fourth reason is caring for someone who's quarantined or self-quarantined, and it relates to someone who's subject to the order under item 1 or healthcare provider recommended quarantine under item 2. And keep in mind, for caring for an individual, the key issue here is you have to have a relationship with that person that you're caring for. If you do not have a relationship with that person, so you want to volunteer and help care for people, what have you, that's not going to cover this kind of qualifying reason. The fifth one is child care. This is caring for a child whose school or place of care is closed. And again, remember this, like the other reasons, you can't work because of this. You're unable to work or telework. That's when this is triggered. And then, as I mentioned a moment ago, substantially similar condition. This hasn't really been developed yet. We'll see to what extent the Secretary of Health and Human Services expands on that or adds to this, but it's something to watch for. For emergency family medical leave, there is just the one reason. It's child care for school or place of care that's closed. This is the exact same reason as sick leave reason number 5, and we expect employees who are qualifying for this kind of leave will at least explore the opportunity to use them concurrently, but we'll get into some of those details in a little bit. As we note on this slide, emergency family medical leave does not cover these other reasons. So a lot of us who are used to the family medical leave are used to evaluating leave requests due to serious medical conditions, caring for someone with a serious medical condition that's in your family, et cetera. And in some respects, the emergency family medical leave really is just on the specific reason related to child care. It doesn't relate to the other medical reasons for leave under this statute. Those are all under the sick leave portion of it. So we want to just make sure everybody has a good understanding of that distinction. With respect to the pay rate and caps for the various leaves here, there are really 3 buckets you need to be mindful of. For the first 3 reasons for sick leave, it's a person's full regular pay up to a cap of $511 per day and $5,100 in the aggregate over a 2-week period. For caring for a quarantined individual or self-quarantined, it's 2/3 of the pay up to $200 and $2,000 in the aggregate. And then finally, for child care, it's 2/3 of pay up to $212,000 in the aggregate. And the reason it's that much is because you have a total of up to 12 weeks of child care available leave. You can take 2 weeks unpaid and 10 weeks paid under the Emergency Family Medical Leave Act, or you could take 2 weeks of paid sick leave for childcare, and then you get 10 more weeks of paid EFML. That's what we mean when we say EPSL and EFMLA combined. And as we noted, that the employee's regular rate or applicable FLSA minimum wage or local minimum wage, whichever is greater. So in those states where minimum wage is higher than the federal rate, you're going to look at that higher minimum wage to determine the pay rate. And with that, I'll switch it over to Brian.
Yeah, thank you, Peter. So let's jump into some regulatory developments on the first thing that comes to mind, which is, am I covered by this at all? And there was certainly guidance in the Act itself, but the regulations flesh that out a little bit. And so let's just cover a couple of key points. The first is, generally, coverage is for private employers with fewer than 500 employees and for state and local government employers, regardless of size. If you have 1 employee or 1,000, it doesn't matter for state and local governments. But for private employers, you have to have fewer than 500 employees. And this includes for-profit and non-profit entities. It includes religious entities. So if you're a private employer itself, you are in the bucket, assuming you have fewer than 500 employees. One thing that was unclear, we mentioned this in the last webinar, is, okay, when do I determine that? Is that as of the date the Act went into effect on April 1st, or is it another time? And the short answer is, it's another time. It's actually determined at the time an employee actually would take leave. And so if somebody says, I plan to take leave next week on Friday, the determination takes place as of the count that exists as the time the employee takes that prospective leave next Friday. It's a snapshot in time. What that means, unfortunately, is if you're close to the edge of that count, you can, in theory, move in and out of coverage. And they gave some examples in the regulations and the preamble about that. So if, for example, I'm an employee and I'm at an employer with fewer than 500 employees at the time I seek leave, and I go out, I remain covered for that entire period of leave that I'm seeking it, assuming that I don't return to work and assuming nothing changes in that count. So even if, while I'm out on leave, my employer had, 499 employees when I went out, and then they hired 4 more people, that doesn't change my leave. I'm still entitled to that leave as long as I stay out on that leave. But if I come back after that leave, and then I need later, EFMLA leave, for example, and my employer's numbers have changed to go above 500 at that point, I do not get FFCRA leave again because I'm out of coverage. The employer is out of coverage. The same thing is true with respect to if the employer later hires added personnel for other people. Just because you granted it to other employees doesn't mean that other employees that become later to you and raise their hand later, if you cross the 500 mark later, they can be excluded. So they can't come and say, well, you gave it to Brian, now you need to give it to me. Well, not necessarily. That's not how it moves. The employer coverage actually can be a shifting target. That raises another issue, which is actually, so who is included in that count? And there were some things in the regulations that came out that we were not surprised at, and then there were some things that we were. So I'll tell you what's included. It's part-time and full-time employees. This is for the count, regardless of how long they've been employed with you. This is not whether they can take leave itself. This is who goes into the 500 bucket. It includes employees of joint ventures and other joint employers. There's not a surprise about that. It includes employees of parent companies who are deemed to be, quote, integrated subsidiaries and parents following the FMLA sort of integrated employer test. It includes employees on leave of any kind, assuming that they remain employed. That's sort of a no-brainer, but we'll talk a little bit more in another slide about that. But here's a couple of surprises. It includes, quote, jointly employed temp workers and day laborers supplied by a temporary placement agency. And so for plants and operations, for example, that employ a lot of temp workers, but you're not the primary employer. It's ADECO or it's Manpower. Technically, the DOL is saying those individuals get included in the fewer than 500 count. And if they push you over 500, in theory, it pulls you out of coverage. This is odd. Frankly, Peter and I have been having some debate about this. It's odd because on one hand, all these individuals the DOL is saying are included in the bucket. But from a leave standpoint, if one of these temp workers raised their hand and said to you, I hereby want to take FFCRA covered leave, the short answer would be, go talk to your other employer. That ain't me. I don't give you leave. That's up to a DECO. That's not up to us. And so it's interesting that for purposes of the count, they're in the bucket. But for purposes of leave itself, not so clear about that. So that's an unusual anomaly that, frankly, none of us were expecting. Which also raises the question, so who's not included in the count? Well, it's clear that employees that are employed outside the United States or in a U.S. territory or possession, other than a U.S. territory or possession, they are not included in the count. So even if I have an employee that may be normally employed in my Chicago office, but they're on assignment in Europe for a year and they're working in Europe, they're not included in that count. The count also does not include independent contractors, but that assumes, again, that they are true independent contractors, and that assumes they're not, quote, jointly employed temps or day workers, which frankly typically are independent contractors. And so you got to be careful about that. And here's an interesting note. In the regulations, they said, well, when you're thinking about who's not included in the 500 count, it does not include employees who have been laid off or furloughed and have not subsequently been reemployed. That's the language for the regulation. The layoff we get, because you're laid off, i.e. I've been fired, and possibly might get rehired later, but I haven't been rehired yet, well, then I'm not an employee, so by definition, why should I go in the count, right? I'm not employed. But the concept of people who may have been, quote, furloughed seems to conflict with the earlier language, because technically employees who are on leave, they say, are included in the count. But a furlough, frankly, is technically another form of unpaid leave. So on one hand, they're saying you should count them. On the other hand, they're saying you should not count them. And that's sort of an unusual anomaly. And frankly, there's a lot of furlough activity going on. And for individuals who may have been furloughed, the concept that furloughed employees may not be included in the count, you might have a lot of organizations that pre-furlough were above 500, post-furlough are now below 500, and in theory, if you look at the regs strictly, you might now have coverage for the remaining people who are still with you and not furloughed. And that would be a really strange anomaly. We're not sure if that's what it means. That's one way to interpret it. Another way to interpret the language is no, when they say have not subsequently been reemployed, it's implying that you must have somehow lost your employment status. And so if maybe they just sort of misused the term furlough, and they'll clarify that in later regulations. But right now, sitting here today, frankly, we can't tell. And hopefully we'll get some additional DOL guidance on that.
One thing I would add, Brian, just real quick on the last one. Just as a note, independent contractor issues are complicated and they vary by state, especially those of you all who have operations and employees in California. You have a new, much more relaxed independent contractor standard there. So as you're evaluating your employee count and looking at independent contractors, it just bears mentioning to remember to maybe take a fresh look at that so that you are comfortable that you have properly classified someone as an independent contractor and therefore excluded them from your 500 employee count. And that also will be useful if you get a request for leave from someone who you believe is an independent contractor. You'll be able to be prepared to deal with that request as well.
Great point, Peter. Thank you. Other things to consider, there's separate from who's not included into the count, there's actually a small business employer exemption that gets you out of FFCRA entirely. In theory, we thought that's the way it was going to work. Actually, though, when the regulations came out, it's not what that provides. The small business employer exemption does apply to employers who have less than 50 employees, but you have to be able to show that the FFCRA's requirement, quote, would jeopardize the viability of the business as a going concern. And here's the key point. It only applies to the extent that someone is requesting leave for child care reasons, which is basically the paid sick leave reason number 5, and the only reason you can take emergency family medical leave. So we thought that the small business exemption might apply to all of FFCRA. It does not. It only applies to one subset of it. And in theory, if you apply it as a small business, it can be applied as to particular employees, or assuming you meet the test, all of your employees. There is a 3-part test, but it's an or test, not an and test. And I'm not going to spend much time on this. You can look at it at the deck, but basically it's for leave where granting the time would result in the business's expenses and financial obligations exceeding available business revenue and cause the small business to cease operating at a minimal capacity. Basically, it's a financial exigency sort of exception. Or the absence of the employee requesting leave would, quote, entail substantial risk to the financial health or operational capabilities because of their specialized skills. So that's because, you know, your IT person, I can't live without my IT person right now. If they went out, everything would cease. Well, they have their specialized skill is what puts them into that category, and that would be a separate exception. Or there's a third exception, if there are not sufficient workers who are able, willing, and qualified, and who will be available at the time and place needed to perform the services. And those services are needed basically for you to operate at a minimal capacity. So they don't necessarily have special skills, but I just can't find anybody else to sub for them. And if I don't, frankly, things grind to a halt. It's not an and test, it's an or test. And so as long as you can show that for the given employees at issue and document it in theory, you can get yourself out of coverage. But again, you're only getting yourself out of coverage as to the child care portion of the triggers. For everything else, even for small businesses, you are still covered by FFCRA. That also brings us to the employees. Which employees are covered? Well, not everybody necessarily. For paid sick leave, it is everybody, all full-time and part-time employees, no matter how long you've been employed. That's not a surprise. That was in the Act itself. As to the emergency family medical leave, it's full-time and part-time employees employed for 30 or more calendar days. The regs flesh that out a little bit and talk about how that 30 days is calculated. It also makes it clear that those 30 days include time spent if you've been assigned to an employer by a temp agency like Adecco, and then you're later hired by that employer. All that time gets added together. Or it also includes time if you were laid off or otherwise terminated on or after March the 1st of this year, and then you're later rehired on or before December 31st of this year. And if before that layoff you were on the payroll for at least 30 of the last 60 calendar days prior to layoff, then when you come back, you're automatically sort of bootstrapped back into FFCRA. You don't have to wait for an additional period of time, another 30 days before you're qualified. You sort of get the benefit of your prior employment. And again, this was interesting. It's interesting that they have this special language in here about temps. Again, it sort of proves our point that temps beforehand really aren't covered by the primary employer, or the secondary employer. The temps are covered by Adecco. That's who actually has to give them the leave rights. And this sort of regulation sort of points this out. So that, again, that's an anomaly. That's fairly strict about who gets in and who gets out. There are exceptions to this. And before I turn it over to Peter, let me just point out that separate from the small employer exception, there's an exception that's related to employees themselves if an employer employs healthcare providers or emergency responders. And we had some debate about this on our last webinar. What does that mean? How broad is healthcare provider? Is it limited to the FMLA definition of healthcare provider? Or is it broader? And the good news for people in this situation who are in the medical profession is that these regulations make it very clear that these exceptions are extremely broad. It's an option. You don't have to do it. You can opt out of coverage or you can stay in a coverage. It's your employer option. But as for healthcare providers, it's very clear that it includes, quote, anyone employed at certain institutions. That includes doctor's offices, clinics, hospitals, nursing homes, medical schools. It also includes, per the regulations, nursing facilities, retirement facilities, home health care providers, facilities that perform laboratory and medical testing, pharmacies, and, quote, similar institutions. It also includes contractors of those institutions and medical services and suppliers in order to sort of keep those operations running. So it's very broad. The same thing goes for the emergency responder exception. It's also very broad and includes, quote, anyone necessary for the provision and transport care of healthcare, comfort, and nutrition to patients, quote, or others needed for the response to COVID-19. And the regulations, again, sort of provide a bunch of examples. They're not limited to certain things, but they say, well, that includes people like military and National Guard, law enforcement, correction institutions, firefighters, EMS, physicians, nurses, public health personnel. Those make sense. But then it goes on and says, besides EMTs and others, it says 911 operators, child welfare workers, public works personnel, and, quote, persons with skill or training in operating specialized equipment or other skills needed to provide aid in a declared emergency. So again, it's very broad. So if you think you might fall within those categories and you're thinking about exempting individuals, you might want to get a look at that and certainly talk to us about how to do it. Again, you have to opt out. How do you do that? You simply tell employees you're opting out. Provide them sort of an email or other written notice telling them that they're not going to be covered. You do not have to send something in to the Department of Labor. You do not have to file a form to opt out, but you do need to keep a record somewhere of what you've done. And with that, speaking of work, I'm going to turn the next section over to Peter.
Thank you, Brian. Okay, so we're going to switch gears a little bit now to a really important concept that I think it's important to keep in mind as we're evaluating all aspects of both the sick leave and the family leave provisions of the Families First Act, which is the employee is unable to work or telework. And this is an underlying concept that is throughout the statute, and there was some confusion as to how this actually would work, if a business is closed, what have you. So we're going to talk about that now. What the regulations say is that an employee must be personally unable to work or telework due to a need for leave under one of the reasons under the employee emergency paid sick leave or the emergency family medical leave. What does telework mean? Telework means that an employer permits or allows the employee to perform work while the employee is at home or someplace other than the employee's normal workplace. And there are three basic tests to teleworking. Does the employer have work for the employee? Does the employer allow the employee to perform work from the employee's location, someplace else other than their regular workplace? And there are no extenuating circumstances, I love that clarity, such as serious COVID-19 symptoms that prevent the employee from performing that work. So the first two are pretty straightforward. The third, no extenuating circumstances, that's going to be the one that could be the most difficult. And the example, serious COVID-19 symptoms, makes sense, but there could be other extenuating circumstances that implicate and impact someone's ability to telework. With respect to the orders that have been issued all across the country regarding shelter in place, it's important to point out that in some circumstances, orders that advise some or all of the citizens to shelter in place or quarantine, can impact the ability to work or telework, but it's not automatic. You have to look at the circumstances. And I think the key test that, at least in the regs, makes sense and one to follow is if the employer has work for the employee, even if there's a shelter-in-place order, because maybe they're critical infrastructure, or maybe they've got everybody at home because it's a office environment, then the employee, or they can telework, then that could trigger a need for leave. But if there's no work because the employer's closed, then the leave would not be available. And I'll get into an example about that in a minute. And as we note on the slide, as I just mentioned, it's if there's not any work for the employee, even that individual employee, the leave isn't available. So let's look at this example. The cashier previously worked at a coffee shop, subject to a stay-at-home order, would not be able to work even if he were not required to stay at home. As such, he may not take paid sick leave because his inability to work is not due to the requirement to stay home, but because his business is closed. In fact, both are taking place. He's been asked to stay home and his business is closed, but the regs make clear if there's no work to be performed, in this case, because the coffee shop is closed, then he's not entitled to leave. And I just want to note here, shelter-in-place or stay-at-home orders where a business is not essential do not trigger the leave by itself, okay? So it's a really keep coming back to that, does the employer have work for the employee? And then is the employee unable to work due to a protected reason or provided reason? The example in the regs goes on to even elaborate any further, as this slide indicates. If the closure of the coffee shop was substantially caused by a stay-at-home order. For example, if the coffee shop is closed to its customers being required to stay at home, the reason for the cashier being unable to work would be because those customers were subject to the stay-at-home order, not because the cashier himself was subject to the stay-at-home order. My regular Starbucks is closed, so I have to go to another Starbucks that has drive-through to get coffee if I want it, and there are people working at that Starbucks that are offering drive-through services. They are able to work and there's work for them. If they need to take leave, that would be an example where that employee may be eligible for leave. Starbucks has got too many employees to be covered by the act, but if they were, that would be the situation. At my other Starbucks, where everybody's not there because they've closed it and they don't have any other services, that's not going to lead to a triggering event for leave. For furloughs, we've been getting a lot of questions, and you all may have also been wrestling with a lot of questions about furloughs. And we suspected that the regs would go this direction, but we weren't sure, and part of that uncertainty surrounded the fact that furloughs are really a poorly defined word. A lot of companies and folks use that term loosely to mean all different kinds of what I would call unpaid time away from work, whether it's due to a downtime or maintenance or some other reason. The regs make clear that if the employer is open but furloughs the employee on or after April 1, they're not entitled to sick leave or medical leave because there is not work for that individual to perform. So they're not entitled to take sick leave or medical leave. Let's say the company normally has plenty of work going on, but they've closed the facility for a particular reason. Maybe there was a positive test and they need to do extra cleaning, whatever, and there's no work to be performed because the facility is closed. That kind of furlough or temporary suspension of work would not qualify someone for one of the paid sick or family leave benefits. And that also applies if we actually have to do a total closure. We do a reduction in force. We take other steps to impact work. As long as there is not work for the employee to perform, the leave is not available. Also, a qualifying reason must be personal to prevent that employee from working or working a full-time schedule. It must apply to him or her. And we think that this is pretty consistent with the intent of the Act, that it impacts the individual employee's work duties, responsibilities, obligations, etc. For self-quarantine, this area was one that we expected to see some further development in the regs. There was a lot left to be desired from the statute itself. The regs make clear that when you are asked for self-quarantine, it has to be as a result of the direction or advice by a healthcare provider. Or you have symptoms and you are seeking a medical diagnosis. So in both situations for self-quarantine, I think a good rule of thumb is you can determine whether or not and ask whether or not the person who's asking for the leave because of self-quarantine has been advised by a healthcare provider that that's what they need to do. Or if they say that they've got symptoms and they feel like the best thing to do is self-quarantine, you can and should ask, are you seeking a medical diagnosis? That is specifically required for purposes of being able to say that you are eligible for the leave. The healthcare provider definition here, in contrast to what Brian just covered with respect to the types of employers who can exempt themselves out of providing leave, is the one that we use and we're used to under the FMLA. So this will be those types of medical providers you are typically asking employees for certifications for medical reasons, et cetera, for regular FMLA leave. The key thing is not to confuse this with the opt-out definition that is in the statute for employers that can deny leave to employees who are needed for driving an ambulance, tending to the emergency room, et cetera. Also, you can't take leave if you decide on your own to self-quarantine for an illness without medical advice, even if you have those symptoms. So this is important for employers to be able to do essential due diligence, if you will, that the regulations specifically allow employers to ask in order to determine if someone's self-quarantine is really a covered self-quarantine for purposes of these leave statutes, or whether the person is self-quarantining on their own without actually getting any medical advice or without being told by a healthcare provider they're doing it, or they're not actively seeking a medical diagnosis. A general, oh, I'm thinking about going to the doctor, I don't think is going to be sufficient. They need to actually take that next step. There will be some close calls in trying to administer this. We appreciate that this is going to be and present some challenges, but that, I think, is a fair reading of how the statute and the regs lay this out. Additionally, on self-quarantine, the healthcare provider has to believe that the employee has the COVID-19 illness, may have it, or may be particularly vulnerable to it. So each of those three, it's important that the Act provides that we have a medical care provider making that determination. And for self-quarantine, it must prevent the person from working. So if they can telework, then they're not entitled to the leave. But if they can't work or telework, then they're entitled to the leave. So think about the three bases that I've mentioned earlier about what constitutes teleworking, and then whether or not the person can do their job. If they're suffering serious symptoms, they may not be able to telework, as one of the examples we talked about earlier touched on. So with that, I will switch it back over to Brian.
Yeah, thank you, Peter. Just one thing to add to what Peter said. On the self-quarantine side, we weren't surprised by the first two bullets. You have COVID-19, or they think you may have it. But the idea that a physician can write you out for FFCRA-covered leave because you're vulnerable to COVID, you don't have it, you haven't necessarily been exposed to somebody who has it, and you're being self-quarantined, but you have severe asthma, or you have type 2 diabetes, or you have something else that potentially puts you in a, quote, a high-risk category. In theory, the way this works is a healthcare provider can write you out for that because of that vulnerability, and assuming you're required to self-quarantine as part of it, you would be covered under FFCRA. That probably is an expansion of what we thought was coming out of the Act, and frankly, it's a huge expansion. It may put a lot of people into play who weren't otherwise going to be covered. So just keep in mind, we'll have to see how that plays out as a practical operational issue. But even though we thought the first couple of buckets might be fairly narrow, that third bullet, in my mind, really expands out FFCRA in a huge way. Speaking of other things, I'm not going to spend much time on the symptoms diagnosis part. Peter did a great job sort of summarizing it. Again, the key point here is if you're experiencing symptoms, you have to actually be seeking a diagnosis. You can't just self-diagnose yourself with symptoms and stop there. You then have to actually go seek help in some fashion. But the regs are clear that if you go for testing and you don't meet the criteria for testing, or you just simply can't get a test, which happens, but you're told to self-quarantine, you remain eligible for sick leave. So I think that's a fair clarification. And the regulations also, again, like Peter mentioned before, make it clear that like self-quarantine, if you're out because of symptoms and diagnoses, it's got to be out, and you must not be able to work for part of that time. But if you can telework during that period of time and you're not otherwise having such severe symptoms that you cannot work, that leave could stop. By the same token, though, the regs are clear that if you cannot telework, you're allowed to seek leave, quote, regardless of the severity of the symptoms. And so you don't really want to be second-guessing the symptoms. So whether or not, for example, someone has a cough but no fever, well, a cough is enough. Assuming they cannot telework, then that would put them out of leave under that provision. Care for a qualified, a quarantined individual or a self-quarantined individual. There's a lot of debate we had before in the last webinar. What does that mean? Because individual in the Act itself was not defined. It just said a person, an individual. Now we have a definition. The regulations say that the employee must have a personal relationship with the person needing care. And they give some examples. Immediate family member, a person, quote, who regularly resides in the employee's home. And believe it or not, I think that does include your teenager. Even though they might be out of the house for 90% of their time, that still, quote, regularly resides in your home. But that it also includes, quote, a similar person with whom the employee has a relationship that creates an expectation that the employee would care for the person if he or she were quarantined or self-quarantined. You have to have a relationship. You can't simply volunteer out of the goodness of your heart to care for others with the Red Cross or others and apply for FFCRA under this rule. That's a great thing to do, but it wouldn't get you into the care for other individuals trigger. The other thing that the regs specified is that the employee must have, quote, a genuine need to care for the individual. How you're supposed to figure that out, I'm not quite sure, but to the extent that you determine that someone really isn't genuinely caring for someone and they're out, I don't know, fishing instead, then again, they would not be covered under this provision. Childcare. One interesting thing about childcare, there was something in the regs that jumped out to us. And I think, frankly, the Department of Labor is worried a little bit about abuse. And this is something that was not in the Act, but is in the regulation. So first, the regulation said, hey, if you're out for childcare because the school is closed or your childcare provider is unavailable, it's only if and to the extent you are actually needed to care for that child. You actually have to be caring. It can't be just theoretical, the school is closed. You actually have to care for the child because the school is closed. And here's the other interesting thing. It said, secondly, generally an employee does not need to take such leave if another suitable individual, such as a co-parent, co-guardian, or the usual child care provider, is available to provide the employee's child care needs, or the employee's child needs. And so basically, if there's somebody else who can do it instead of your employee, and they're sort of reasonably available to do it, then in theory, they're not qualified for this child care leave. Now, how you're going to figure that out? Good question. DOL regulations are frankly silent on how you should determine who else is available. I guess in theory you can ask questions about that, but that's going to be extremely hard to sort of second guess. But in theory, if you can prove that somebody else is available and willing to do this, then that other employee, your employee, would not be qualified for the child care portion of FFCRA. That also sort of brings us into concurrent leave. And these next sections I will tell you are hyper-technical, and so I'm going to go over them, but I would encourage you to reread these slides again. It took us a lot of time to sort of think through the new regulations on how this works. It's complex, it's confusing to us, and I'm sure it's confusing to others. It's confusing in part because the rules on concurrent leave and intermittent leave are not the same as we regularly deal with under high-test regular FMLA. I mean, I think all of us are used to how those rules work and when I can make somebody use concurrent leave and when I can't, and when somebody can take intermittent leave and when they can't. When I've been dealing with these regulations, I sort of have to sort of try and forget all those other rules because they do not apply to FFCRA. They're different under FFCRA. So let's start with concurrent leave. Under concurrent leave, employees may, they don't have to, but they may opt to use employer-provided paid leave like PTO and vacation to supplement paid sick leave or paid FMLA leave under FFCRA. But for the first 2 weeks, if somebody wants to do it, you have to agree to it. So they can raise their hand, but if you say, no, I don't want you to do it, you can prevent them for the first 2 weeks. Otherwise, they may opt. What you cannot do under FFCRA is you cannot require employees to use available paid leave during those first 2 weeks. They can opt to do it, but you can't make them. And you also can't require them to use your PTO, vacation, etc. prior to using emergency paid sick leave. You can't say, like you normally would, hey, before you can use this law, you have to exhaust all your regular PTO and vacation with us. That's not the way it works. People get to use their emergency paid sick leave first if they want to. What you can do, though, is you can require employees, just like regular FMLA, to use available paid leave concurrently with the Emergency Family Medical Leave Act, but only after the first 2 work weeks. For the first 2 work weeks, which were otherwise covered by emergency paid sick leave, you cannot make them. They can raise their hand and do it, but you cannot make them. After that first 2 weeks, for the rest of the 10-week period, you can. For example, if you want to make them burn off their paid PTO and vacation concurrently to deal with the other unpaid 1/3 portion, you can make them do it just like any other regular FMLA leave provision. So that's confusing, I think, very confusing. The other thing with respect that comes up a lot is, well, what about intermittent leave? Can I make people do intermittent leave? When can we do it? And again, FFCRA is unusual because the derivations of the law are unusual. FFCRA provides that with respect to intermittent leave, it can happen, but both you and the employee have to agree to it. If either one of you balk, intermittent leave cannot be used. The other interesting thing about intermittent leave is it depends on where the employee is working. If someone is teleworking, the rules are very clear that you can use intermittent leave for any reason under paid sick leave or FMLA. So any of the 6 qualifying triggers, whether that's quarantine, self-quarantine, child care, you name it, you can use intermittent leave. So for example, going back to the child care provisions that Peter were talking about, to the extent that people are having a hard time and they just can't cover their regular schedule because of child care and the need to homeschool, et cetera, but they can work 2 or 3 hours a day, well, you can do intermittent leave. and you don't have to take the full day of leave, and you can work 2 hours, assuming, again, you, the employer, agree to that. That's perfectly acceptable. But FFCRA says, wait a minute, for people who are at the employee's work site itself, you can only agree to use intermittent leave with the employee if the leave is for a child care reason. If the leave is quarantine, or testing positive, or self-quarantine, or you're waiting on a diagnosis, or for any of those other reasons other than child care, you are not allowed, even if you agree, you're not allowed to use intermittent leave. And the reason for that is, and the preamble makes it very clear, we don't want those employees coming to work, period. We would prefer them to be out, and we certainly don't want them in and out of work, on and off. And so if they're at the work site, if they qualify for leave and they take it, they need to leave and actually be off the work site. You're not allowed them to come and go intermittently under FFCRA, as long as the qualifying reason itself continues, as long as they remain positive, as long as they remain under self-quarantine, they can't simply come and go. Another couple of things we'll mention before we jump into some final questions. Prior employer leave, this is an unusual thing that was added to the regulations that frankly just was not in the Act itself. There is a provision in the regulations that say that an employee's potential sick leave entitlement under FFCRA applies per person, not per job and not per employer. And what the regulations say is that if an employee took emergency paid sick leave under a prior employer, and they used it all up, they used their entire 80 hours, they do not get another 80 bucket with you if they get reemployed by somebody else later. Likewise, if they use, 23 hours with employer number one, and then they join employer number two, that entitlement is reduced by that prior 23 hours. Now, the regulations are absolutely dead silent on how you're supposed to figure this out. Peter and I were talking about this earlier. I'm not, with the exception of DOT drug testing regulations for truck drivers, we're really not aware of any kind of prior employer requirement. You really don't see this pop up in normal employment regulations, but it's here. So just, it's a fair question, I guess, if you have new hires under the Act and they want to sort of take emergency paid sick leave. As I understand it, you can now ask, okay, under your prior employer, did you take emergency paid sick leave and how much? And to the extent that they did, you're required to sort of take that into account when you're sort of calculating the remaining available time for you and the tax credits, frankly, that you can get for that employee. One other thing I'll just mention under job restoration, generally, employees must be returned to the same or an equivalent position upon return to work. That's very similar to the FMLA. The statute's very clear that that doesn't mean that you get greater rights. Basically, you get the same rights had you not been out on leave. Again, that's a very common FMLA concept. There is an exception, a special exception in FFCRA for employers with fewer than 25 employees. And you can look at the test. The employee is limited to employees who are out for child care. The position you have to show is no longer held for COVID reasons. You have to reasonably make an effort to restore the employee, and if you can't do that, you have to contact them if a position becomes available in a one-year period. Interestingly enough, this is baffling to me and Peter, why we have to have a fewer than 25 employee exception, since the macro rule above it would normally take care of it, is beyond us. It seems a little unusual, frankly, because the second bullet of the fewer than 25 employees, that the position is no longer held, seems to get covered by the macro FMLA rule, such that, why I actually need that protection is a little interesting. We're really not sure. In a weird way, it imposes more burdens on employers that have small number of employees than on large employers, which is probably not what was intended by the Act. Interestingly enough, there are no FAQs on this provision as of yet from the Department of Labor, but hopefully we'll get some soon, and maybe they can clarify this one point. The other thing that was interesting in the Act regulations that came out is there's language in there that talks about how the emergency paid sick leave provisions are not grounds for you to diminish or reduce or eliminate other rights or benefits that existed prior to April 1st. And that's not an unusual concept to see sometimes in regulations. But then they went on to say, we interpret this to mean that if you were providing on your own before the April 1st, extra or supplemental PTO, sick leave, you name it, before FFCRA went into effect, and then after FFCRA went into effect, you thought to yourself, I want to dial that back a little bit to make a little bit of an offset since I now have this extra regulatory burden. The DOL, at least right now, says you cannot do that. You are stuck in place with what you adopted prior to April 1st, and if you try and dial those provisions back, that is deemed to be sort of an interference violation of FFCRA. Again, this is sort of the no good deed goes unpunished rule. I don't think employers are very happy about this, especially people who are trying to be generous. But as it currently stands, that's the DOL's take. So with that, I know we're out of time, and we want to be respectful of that, but I think we've gotten a number of different questions. And if you stick with us just for a couple of minutes, I think we'll try and take a couple of them and then wrap this up. So Peter, you want to close this out with some questions?
Sure. Thanks a lot, Brian. So one question that has come up that I think may be helpful to everyone is, what are my obligations to maintain health care for employees on leave? And there are really, I think, 2 points to be made on this. There's additional detail in the regs, but as you may expect, an employer must maintain health care coverage the same way and pay the employer's share of the employee's health care coverage during any sick or emergency family leave under FFCRA. If the employee does not pay his or her share of their medical benefits, then they can jeopardize retaining those. So it's a two-way street. The employer has to maintain it. The employer continues to pay its share, and the employee pays her share. If an employee does not maintain their coverage and they let it lapse, when they return to work, the employer must reinstate them in the plan without any waiting time, qualifications, or other conditions. It must be basically immediately reinstated back into the plan as if they had not left the plan and decided not to continue to participate in and receive medical benefits. So important piece there on how to put someone back into your medical plan and what, if any, restrictions may you impose. The short answer is you really can't. Another question is, how do I handle leave sequencing? We have a PTO policy that is very generous, but we are also looking at the impact of doing so and how that may influence the tax credits our company can receive. So a couple of points on this. For sick leave, you can't require the employee to take any other leave, as Brian mentioned earlier and we've discussed. So that won't be an issue there. But for family leave, you can require the employee to take other PTO at the same time, which will run concurrently with the emergency family leave. But just note, when you do that, two things happen. First, the employee is entitled to the pay that he or she would receive under that leave in the normal course. It's not the lower amount of leave because technically they are taking paid time off at their regular rate, for example. But also importantly, your tax credit is not that higher amount. Your tax credit will be capped at the $200 a day, $10,000 total for emergency family leave. So employers will need to weigh the employee relations side of allowing an employee to take more, take personal leave that or PTO that's already available against the desire to obtain the maximum tax credit, manage their cash while they're doing it, and still meeting the requirements to comply with these statutes. So I think that's where we'll stop. We're sorry we went over a few minutes. There's a lot here, and we certainly appreciate that you all are wrestling with a lot of questions from a number of different angles. As we mentioned earlier, feel free to reach out to us. On the next slide is our contact information. We will also get back to you on your questions. It may take a few days, but we'll get back to you on those as quickly as we can. And once again, thank you very much for attending today, and we appreciate the opportunity to work with you all and talk with you about this statute. We hope you have a great rest of your week and a great, safe rest of your week as well. Thank you.
Thank you, everybody.